Guys, this is Erica from Gokce Capital. Now before I begin, be sure to click subscribe and turn on the notification bell. Imagine this. You have hired your long-standing handyman to complete a few repairs in your kitchen. While he is working, you pass by and start up a conversation. It may be a few days before I can come back, he said. I have to be out of my apartment tomorrow and don't have a new place yet. Where are you staying? You ask, concerned. Not sure yet, he responds, but I bet a friend will let me crash for a few nights. You hesitate for a moment, but then find yourself saying, why don't you stay here for a day or so? You've done so much work on the house, it might as well be yours. You're a bit surprised by this suggestion. It's certainly more generous than the words of common concern you would normally offer, but hey, why not? It's the Christian thing to do after all. You'll later come to regret this decision, but more on that later. For first, this scenario highlights a unique problem facing landowners or the hospitable property owner that he then abuses. How do you evict a person who is not a formal tenant? Well, in today's video, we are going to cover ejectment actions, one option you may have, and how they differ from evictions. Number 1, an ejectment action is a common law term for a civil action to recover the possession of or title to land. Unlike an eviction, there is no lease or landlord-tenant relationship with the person on the land. Having said this, the person that the owner of the land wants to eject does usually have some sort of claim to the property, such as a land contract. Number 2, every state has a slightly different procedure, but at a high level, to bring an ejectment action, you usually follow these steps. You get a local real estate lawyer to advise you throughout the process. This is very important because not only does the ejectment action process vary from state to state, but also the scenarios under which you can use it. You will then need to establish that you are the true and rightful owner of the property. At this point, you can file a suit in your local circuit court. When the suit is filed, the defendant will have time to respond. If the defendant doesn't respond, you will likely receive a default judgment, which will then allow you to call in the sheriff to remove the defendant from the property. If the defendant does respond, then a hearing will be set so the judge can listen to both sides, at which point the judge will issue a ruling. Again, if the judge rules in your favor, you can have the sheriff come to the premises and remove the defendant. Number 3, in some states, such as Florida, the defendant can file a betterment within 20 days of the verdict. If the defendant made any real improvements to the property, they could exercise their legal right to sue for reimbursement for those improvements. This is what the betterment is. So even if you win the case, it's possible that the defendant can sue for recovery of any improvements they made. And this is why it's important to discuss with a real estate attorney before filing an ejectment action, so you understand all potential outcomes. Number 4, alternatively, eviction is the removal of a tenant from a rental property by the landlord. An eviction requires a written lease, mortgage, or some sort of tenant-landlord relationship. As we mentioned earlier, this is often the primary distinction between evictions and ejectment actions. Number 5, an eviction has a slightly different process in most states. Again, though, you'll want to consult with a local real estate attorney to understand how evictions work in your jurisdiction. But at a high level, the steps often look like this. You must serve a written notice to the tenant to vacate. The tenant will then receive a summons and a complaint if they do not. The tenant will have time to respond to the complaint, at which point the tenant and landlord go to court, and if the court rules in your favor, eviction occurs. Number 6, most states have a number of protections in place for tenants, so several things will need to occur before an eviction can take place. But again, this varies from jurisdiction to jurisdiction. The tenant must always receive a written notice to vacate the premises before they can be evicted. In addition, the tenant must be served with legal paperwork. The tenant must also be allowed to respond, and a court must grant the eviction before it can proceed. If the court does grant the eviction, a writ of possession must be posted on the premises. And one other thing to note, again, state laws often have protections in place for tenants, and there are certain things you cannot do while you're in the eviction process, such as changing locks, removing doors or windows, or removing personal property. But again, check with a local attorney to make sure that you are in compliance with all laws. Number 7, To determine whether an ejectment action or eviction makes sense for you, consult with a local real estate attorney. Every state has slightly different criteria for these two actions. But if you are an owner of vacant land and you are trying to remove someone occupying the property, an ejectment action may be a good place to start. So that covers the basics of ejectment actions and evictions, but we're not done yet. As a bonus, I'm going to cover one additional action that you should know about, for it can help you with some of the worst case scenarios a property owner may face. So let's return to the offer of hospitality you extended to your handyman. Now, this is actually a real case that happened in Clay County, Florida. Cheryl Cates did actually offer to allow her handyman to stay in her home for a few days. But those days turned into 2 weeks and then 6 weeks, and the man refused to leave. Things got so bad that she even had to put deadbolts on her bedroom door. She called the sheriff's department and they told her that she could not actually evict her handyman. At first she thought this had to do with the COVID-19 ban on evictions, but it turns out the problem was he was not a formal tenant. She then went to the Clay County Courthouse and was given a notice to quit. This is a simple notice that she pasted on his door and her door. However, while easy to obtain, this kind of notice is not court enforceable and did not offer much help. In the end, she went to a local attorney and was told that what she needed was not an eviction nor an ejectment action, but rather an unlawful detainer. And this is an action that in Florida is filed against someone who is neither a tenant nor has any real claim to a property. Now, details vary from state to state, but an unlawful detainer is what you may need to use to evict a friend or family member who has overstayed their welcome. Hospitality is a virtue nearly as old as mankind, and one should never be afraid to extend it. For this reason, it's a good idea to understand what your options are so you can protect yourself in a worst-case scenario. Now, do you have any stories about ejectment actions or evictions? Let us know in the comments. Did you like this video? You're going to love our Gokce Land Due Diligence program. We'll make you a land due diligence expert in just 7 days. Check it out at gokcecapital.com/glad. And while you're at our website, don't forget to explore our $1 down listings at gokcecapital.com/listings. Finally, don't hesitate to reach out. You can email, call, or text, and we will respond as soon as possible. So thank you for listening, and more to come.